Okay, good afternoon. Welcome back. This afternoon, we are going to pick up H92, an act relating to Human Services Board fair hearing proceedings. And this afternoon, we have witnesses from another section of Vermont Legal Aid, the Disability Law Project. And I have invited them in particular because their cases tend to be a bit different than the other legal aid attorney that we heard from. And so I wanted them to have an opportunity to share with us their thoughts about the Human Services Board, their interactions with it, and any feedback that you might have around the underlying statute and any potential changes that you might propose. So welcome, Kelly and Cami. Thank you for both being here. We'll do a quick round of introductions because this is your first time here in committee. I'm Teresa Wood. I'm from Waterbury, and I also serve Bolton, Bucyrus, and Huntington.
Ann Donahue from Northfield, also serve Berlin.
Hi, good afternoon. I'm Dan Noyes. I represent Wolcott, Hyde Park, Johnson, and Belvedere.
Brenda Steady, Milton, Westford and East Milton.
Doug Bishop, I represent Colchester's Chittenden 20 District.
Good afternoon, Todd Nielsen. I represent Brandon and Forestdale.
Hello, I'm Zahn Eastis from Guilford. I also serve Vernon.
Hello, I'm Representative Esme Cole and I represent Hartford.
I am Julie McKell from Bridgeport and I also represent Middlebury, New Haven, and Weybridge.
Hi, I'm Ray Garofano. I live in Essex and I also represent Essex Junction.
Hi, Lori, Committee Assistant.
Katie?
Sorry, Katie with the Office of Legislative Counsel. And Joe?
Joe Reiner with the Human Services Board.
And then we'll go to Representative McGuire.
Hi, good afternoon, Representative Eric McGuire, Rutland City.
And then our two witnesses. Feel free to introduce yourself and the floor is yours.
Thank you very much. Good afternoon, everyone. I'm Kelly Kazmarski. I am the director of the Disability Law Project at Vermont Legal Aid. I am the successor to Rachel Seelig, if any of you know her. I've been at this job since last June. So I'm coming up on 1 year. Prior to that, I was with the Poverty Law Project at Vermont Legal Aid for about 8 years. So new to Disability Law Project, but not new to Vermont Legal Aid. I just wanted to introduce myself and say hello since it is my first time here. And I also wanted to thank you very much for taking testimony on the issue of inclusion, particularly at a time when that word is not always so easy to use. So thank you for your work today. And with that, I'd like to introduce Cami Naylor, who is a staff attorney and our expert on special education law and other issues as well. So Cami, take it away.
Good afternoon. Good afternoon to the committee and Chair Wood. Thank you so much. My name is Cami Naylor. I'm a staff attorney in the Disability Law Project at Vermont Legal Aid. I am here to offer the DLP comments on behalf of the Disability Law Project on H91. Thank you for the opportunity to testify about H91 and improving accessibility of the human service. Can you hear me okay?
I can. It's just H92. I don't want people listening to be confused.
Thank you. I'm very sorry I misspoke. Thank you for the opportunity to testify about H92 and improving accessibility of the Human Services Board for the Disability Law Project clients and individuals with disabilities. The Disability Law Project gets involved in Human Services Board cases when our clients are terminated, denied, or face reduction of developmental disability services, denied or terminated Katie Beckett Medicaid, and denied, terminated, or face reduced hours in the Choices for Care program. Because of limited legal resources, we are not able to provide representation or other significant legal services to everyone who needs help. One DLP advocate estimated that for every one person we represent at their hearing, there are about 7 others who contact VLA for whom we can only provide advice, but that advice is often extensive. Appealing to the HSB is the only option available for someone who disagrees with the denial or reduction of services. Fair hearings are a complex process to understand for anyone who isn't a lawyer, let alone appellants with disabilities, that makes self-representation harder. Of course, Finding a process difficult assumes knowledge the process even exists. We find our clients mostly don't know anything about the HSB. If they do know about it, they're often confused about its purpose and how to access it, or they're too fearful or intimidated by the process to access it. It's also common that a client receives an adverse benefits decision, and on their notice it says, if you wish to appeal this decision, call. So they call to explain that they disagree the adverse decision and find themselves thrust into a whole new world of legal jargon and mysterious processes. Not only do our clients themselves face barriers in the Human Services Board fair hearing process, but it is also a very challenging process for unrepresented parents and guardians of people with disabilities to navigate. We find we need to give a great deal of advice to help parents and guardians understand the issues facing the client and explain how the process will work. I recently supported a parent who successfully self-advocated before the HSB. Preparing my client's parent for hearing involved clarifying the legal issues and then helping her understand what that meant, explaining what parts of evidence helped and hurt her appeal, helping her to understand what she experienced as a typical parent was extraordinary advocacy and support, working extensively to support her in telling her story and bringing her child's needs to light into a clear, articulate message, helping her to think through what the department's witnesses would testify and how she could respond, all the while supporting and reassuring her that while this advocacy was new and challenging, she was the greatest expert in her child and could use her expertise to give life to their story, a story that the documentation could not adequately illustrate. In consideration of the experiences of our clients in the DLP, we would like to make the following specific recommendations about the fair hearing process. First, improve resources about fair hearings and guides for pro se appellants. The Human Services Board already has a document on their website entitled A Summary of the Fair Hearing Process, but it's not plain language or formatted in a way that is easily read and understood. It doesn't explain key terms the HSB uses like status conference, discovery, and fair hearing. Nor does the current summary explain what to expect at each stage in an appeal. It doesn't tell people what kind of evidence they will need for their hearing, what kind of evidence is not allowed, how to gather evidence, or how to present their evidence at hearing. This summary should provide plain language information, step-by-step instructions for pro se appellants, and a plain language glossary of fair hearing terms. Second, improve notices. The current hearing notices don't state the legal issue a hearing officer will decide. Our clients often don't know whether their hearing notice is for their fair hearing or a status conference. People don't understand what evidence they need to bring, how to get a witness, such as their service provider, to attend, or how to get letters of support and documentation from service providers into evidence. An appellant would have to find, read, and understand the summary of the fair hearing process to know what the HSB can provide, to know the HSB can provide accommodations or an interpreter at no cost. Notices should be improved to include plain language descriptions of the issues to be determined at hearing, information about interpreters, accommodations, and other resources available to appellants. More specific suggestions that the DLP has made are included in the final pages of the testimony that we submitted. Finally, the HSB should include resources with our first mailings. After creating a plain language, step-by-step guide about preparing for a fair hearing that is easy to read and understand, the guide should be sent with the appeal acknowledgement or first hearing notice to all appellants. If they are not already able to do so, HSB staff should be able to answer procedural questions for appellants. We find the HSB clerks and hearing officers are helpful, thoughtful, considerate, and willing to grant accommodations upon request. We are thankful for their assistance to our clients and their willingness to provide accommodations to make the system more accessible. We imagine they have their hands full just keeping up with incoming appeals. And we believe that with the implementation of the new CIS-A reassessments and the grid, the volume of appeals is likely to increase going forward. We recognize that creating better plain language materials and providing procedural guidance to pro se appellants could require additional staff time, but it would make the process more efficient. Finally, and importantly, the DLP supports the HSB getting the resources they need to make the above outlined improvements, which we believe will significantly improve the accessibility of critically important fair hearings for DLP clients and others. Thank you, and I'm happy to entertain any questions from the committee.
Thank you, Cammie. I noticed in the attachment to your testimony, you give some specific ideas about what those the suggestions that you just made, how that language might appear in statute, and so I appreciate that. Also, just wanted to note that if we decide about putting those in the draft, right now this is a short bill, and so we're sort of fleshing out what the bill might look like. Just wondering if you'd be available to Ledge Council should there be any sort of give and take back and forth about your language.
We would be happy to be available to Ledge Council and the committee.
Okay, thank you so much. Okay, Representative Steady.
I guess I'm confused. I'm looking at the summary of the fair hearing process that was, we received testimony from Joseph Reinhardt. It was updated December 2024. It is so thorough. I can't understand what you're talking about. I'm not even a lawyer. And to me, this is like step, 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 step. And you're telling me the opposite when I'm looking at it right in front of me and it's so thorough. I don't know what you're talking. Are you not getting a copy of this?
Thank you for the question, Representative Steady. We have seen a copy of that summary and we've reviewed it. Based on our review of that summary specifically, we feel that the formatting of the summary is confusing. We believe that the summary would benefit from a clear articulation of a fair hearing process from initiation of appeal to board decision as its starting point with notes about this is where you are. And finally, having reviewed that, we have observed that we're not confident that it's in plain language.
I guess they should put it in first grade language then. Thank you.
Yes, ma'am.
To me, it's so plain. Okay, thank you.
Yes, absolutely. Thank you.
Other questions from committee members? One of the things that I was wondering about and looking at that same information that Representative Steady was talking about is it, and I'm interested in your feedback about this because it may or may not be helpful to people who are considering filing an appeal. What I have heard from people who have been through the process is that they did not recognize that this was sort of a quasi court-like process, that even though the hearing officers, are friendly and, try to be helpful, they didn't realize that people were going to be able to object to what it is that they were trying to say. And I wonder if it's more clear that this is a sort of a quasi judicial kind of hearing that people might be more prepared to experience the fact that people are may object to what it is that they say. What are your thoughts about that? Would that be helpful or not helpful?
Thank you for that question and comment, Representative Wood. Yes, we believe that a clearer statement that the fair hearing process is a judicial hearing, it's an administrative hearing process, would greatly benefit people. It is our experience with our clients contacting us for support or already embedded in an HSB hearing process that entering it, they did not understand that this would look like or feel like a courtroom proceeding. And again, I think there is an acknowledgement here that as a legal professional, I know what to expect in that environment. I've been trained on what to expect in that environment. And for the last 7 years, I've been practicing in certain environments that are very similar. And so to me, an HSB hearing is less formal than other legal processes that I'm involved in. But for someone who's never been in a judicial hearing setting or a quasi-judicial hearing setting, it is incredibly overwhelming. The process is very confusing. That is why we offer specific comments about the HSB, including in their summary, things like how to gather evidence, how to present evidence, how to get your witnesses to come, because these are barriers to self-representation in a fair hearing.
Oh, one of the things that we're thinking about is and I'm not exactly sure, whether this will end up in something that we vote on, but one of the concepts that we're thinking about is essentially we know that sort of both sides of an argument need to be heard in a hearing. So the appellant side and then the department side need to be heard ultimately in the hearing. And the thing that seems to have been most disconcerting for some people is the fact that they don't really they feel like they don't get to say their side of things because there's objections. And so one of the things we're considering is, whether it is a fair process or not, or in keeping with the intent of the process to enable an appellant, a person who is bringing the appeal, to be able to, state their case, if you will, present their information, essentially uninterrupted, except for maybe people had clarifying questions, and then allow the department to do the same with their side of the case. And then the hearing officer decides and makes the recommendation to the Human Services Board. That would seem a more user-friendly process than the sort of interrogation aspects that people encounter now. I'm just interested in your thoughts about that.
Thank you, Representative Wood. I'm thinking because I think you present a really complicated question, and the question is partially, how does the presentation of evidence and the rules apply in the fair hearing process? Thinking of pro se litigants, I can understand how they would benefit from being able to tell their story interrupted. As an attorney who actively practices in fair hearing cases, there is also power in being able to leverage the process to advocate for my clients, to keep out evidence that is irrelevant. And as I have every confidence in the hearing officers that I have interacted with and whom I have presented cases before. And I do think that the committee would have to wrestle with the implications of understanding that in making a decision to permit people to present evidence in an uninterrupted fashion, that the hearing officers will be hearing evidence that is not relevant and evidence that really should not come into the record. And I just So I think I put your question back to you
Mhm.
in the context of, as the committee is considering such a proposal, it's important to consider information that may be heard in the context of permitting someone to tell their whole story that is not information that is relevant or permissible to be heard in this judicial hearing process. I think that with preparation and clear understanding of what can come in at hearing in primary materials, in primer style materials, you filed a fair hearing. Here's what the process is. Here's what can come in. Some of the concerns for folks feeling like their story is not heard can be assuaged, because in the interactions that I've had and the circumstances that I'm familiar with the issue that you've described, you know, information that's not relevant to the hearing or not permitted to be considered is what's kept out. And so I think that there is a way to maintain a process that upholds the fair decision-making process and a slightly relaxed rules of evidence, and make sure that people can tell their story and that they're truly telling the story that the hearing officer will be deciding upon.
So what I'm hearing you say is that while it could be beneficial, it could also not be beneficial to an individual, because there could be information presented by the department, frankly, that is not relevant to the situation that is being heard. So I'm hearing you say proceed with caution. And thank you. It's helpful to think about it. It's helpful to think about it in that way. And again, how we can make the process more accessible to people so that those folks who cannot afford an attorney, or those folks who are not in a position to receive the representation from Vermont Legal Aid and any one of its projects, you know, they do end up before the Human Services Board. And even those folks who have attorneys sometimes feel like they, you know, didn't have an opportunity to get their story out. And part of what I also wonder about is, earlier on in the process, is there something that the initial provider or the department, you know, whichever department, can communicate with the appellant? So, you know, I can foresee an example about why somebody was concerned that they didn't get to talk about a contract that existed between a designated agency and a home provider. Okay. Not relevant to the Human Services Board in terms of the decision that they're having to make. That was sort of a chief thing that this person wanted to get through. And yet it wasn't really relevant to the decision. And so, you know, there were, I'm sure, lots of objections to that because it wasn't relevant. And I'm just wondering if someone along the way had given them that information, that would be the likely outcome of trying to present that kind of information. Instead, they felt like they were just told along the way, well, if you don't like our decision, appeal to the Human Services Board. And so they actually, I think, were led to believe that they would have a opportunity to present that information when in fact that wasn't really going to be the case. And so I guess I'm just trying to figure out what's a way, you know, how can we encourage relevant departments, even though it's kind of a tricky situation because they're the ones defending their decision, but they're also the ones providing information to the appellants about what their rights are and how to exercise those rights. And you don't want them to dissuade people from appealing, but you also don't want them to lead people on to a process that can be very time consuming, both on their end and on the Human Services Board, and for something that might in the end not really be relevant for that process. And so it's a tough balancing act, and I'm not sure we can put that all into figuring out how to how to modify the underlying statute. And maybe the best that we could do is the updates to the language. And while I find that what they have is helpful information. I think it can be improved upon. And I know that the hearing officers and the Human Services Board are, want to make it as accessible as possible to people. And I'm just trying to figure out how to sort of balance that with the the need to that people play their own parts in this story. And when there's a sort of a potential conflict, like when the department is defending their position, and that's different from what the appellant's position is, they could be seen as trying to dissuade them from appealing if they, gave them information about what the likely outcome of something could be. So all that's to say, I hear your caution and appreciate the feedback about plain language and the ability to provide it in a potentially more accessible format for individuals. And I think being right up front that this is a sort of quasi judicial setting. And I think it's important, not everybody understands that the next step after this, goes to the courts, and that necessitates rules of evidence be followed so that, you're setting it up for proper rulings by the courts after, if somebody decides to go that route. Okay, yeah, go ahead, Kelly.
Cami may have just been about to say this, but I was just going to circle back to what she said originally about editing or revising the existing guidance. One of the things that I think would be helpful is to just have, as Cami has said, a clearly articulated overview, maybe in just a few paragraphs at the beginning, explaining the entire process from the initiation of the appeal to the board decision in plain language. And one of the things Cami and I were talking about is to include the rules as they are currently included in the guidance. It makes it more confusing, we thought. And so to have the rules separate and not part of the plain language description, and then maybe step-by-step procedural overview, that would seem to make it a little bit clearer for the layperson who's not used to dealing with these rules. And that was just one suggestion that we were speaking about. I don't know, Cami, if you were about to say something more along those lines.
Sherwood, I'm very sensitive to the description you provided that in the particular circumstance you described, the family didn't feel like they really had their story heard because a particular piece of information couldn't come in that they believed was the linchpin to everything that they were asking for, if my understanding of your articulation is correct. And I think I'm just mindful, I do a lot of Human Services Board practice, but I also do a lot of educational practice. And in the education procedures and processes and administrative processes, there's a mediation mechanism. And if a parent chooses to go to mediation with the school district and they're not represented, the school district isn't allowed to be represented. And so I only say that to suggest that the department's attorneys are phenomenal. They are so good at their job and they are zealously defending their clients.
There's that term
Yes,
again.
we've learned that phrase of art, yeah.
And that in and of itself, for lack of a better word, the performance of being a lawyer is really overwhelming and intimidating to someone who's not familiar with that. And I wonder if maybe a procedural recommendation, which largely already exists, is perhaps there's an opportunity for some of those objections to be dealt with in advance of the hearing. So if part of a procedure involved sharing discovery, sharing proposed exhibits, if for a pro se litigant, department objections were required in advance of the hearing, and that some of those conversations about whether that evidence was relevant to the proceeding could occur outside in a separate setting from the specific setting of telling someone's story, so that as someone is telling their story to the hearing officer, they've already dealt with the fact that that evidence that they think is linchpin evidence is not relevant and received an explanation of why, so that they can adjust their story and adjust any evidence that they feel like they have to tell at the hearing. I think I cannot understate from my experiences of shepherding pro se litigants through this process how emotionally wrought this is. I think it is incumbent upon all of us to recognize that for folks who are before the Human Services Board, who are appealing an issue before the Human Services Board, the issues that are being appealed are life and death. And I think that the hearing officers and the HSB staff do an incredible job of recognizing and acknowledging that. But I just offer that to the committee as context for what the experience of a pro se litigant is. If I had a circumstance where I received an adverse decision and I needed to appeal to the HSB, I would seek representation. And I'm an attorney.
Mhm.
So I just, because it is so emotional. And I think if you're not that pro se appellant, you have the privilege of maybe not always feeling those life or death circumstances.
No, I think that's well put, Cammie. I just think that's well put. It's much more personal for the appellant than it is for an attorney representing the department, zealously representing their client. And so they're doing that to the best of their abilities, and that will sometimes feel less than humane to the individuals who are sitting in the seat across the table. And not sure exactly how to rectify that, to be perfectly honest. And I think, your statement earlier on when you said having people be more prepared for what it is that they are about to experience will, I think to some extent be able to help that. And yet I feel like as government, we should also have the goal of making our processes as accessible to all individuals, regardless of their disability or education status or anything like that. And so I think that we could do a better job at that aspect of it. And, short of providing a lot more resources to Vermont Legal Aid, to
Which we
hire-
would welcome.
I know, which you would welcome. I recognize that. Being able to provide some advice to individuals in a way so that they understand what to expect, and then it's up to them to make a decision about whether to go forward or not. But they should at least know what they're walking into, and that's not always the case. Go ahead, Representative Garofano.
Yeah, and thank you. This is really helpful, but I also want to kind of highlight what you said about when, if we can construct a way for the appellant to share some of the information before the hearing, I think it's really critical that we have it structure a process that the appellants are told exactly why something is not coming in as evidence, because I think that's been a piece that's been missing, that people aren't understanding, A, why are they not even allowed to talk about something? And B, like, why would it not be relevant? If, like you said, when you're dealing with this, it's all encompassing as an individual when you're advocating for your family member. And to you, all of it is relevant, right? Because you're living it and it all matters to you and it's all relevant. And so really clearly explaining why the rules don't allow, or why something cannot be included in their in the process as evidence or be brought in to be considered, I think is really key.
Absolutely. Thank you, Representative.
Other questions for these witnesses? Go ahead, Representative Bishop.
Currently, is there any level of process of discovery in this fair hearing process?
Representative Bishop, that's a great question. Yes.
He's an attorney, just so you know.
It is, I would say that it's fairly informal, at least in the cases that I represented. We reach out to the department and say, please provide your administrative record. And we get the administrative record. And then typically in advance, and if we have any additional or supplementary evidence, we provide that. Frequently, very practically, if we're providing supplementary evidence, we commonly request that the department reconsider their decision in light of additional evidence that we've been able to provide. Specifically, if that evidence was available at the time that an adverse decision was made. If evidence is not available at a time that an adverse decision was made, we, depending on the circumstances, because it's entirely the department's determination whether they offer reconsideration, we will advise folks to go back and reapply. But anyway, so yes, there is a discovery process. We request the records, we exchange the records, and in advance of the hearing, we commonly provide more specifically what evidence we intend to offer with that listed and very clearly stated. So there is an opportunity to provide documentary evidence that you intend to submit as part of the record in advance of a hearing. And if that timeline could be adjusted to allow for potential objections beforehand, I think that could provide a more meaningful process to pro se litigants who have sincere questions about why their contract is not relevant.
If I may follow up.
Sure, go ahead.
So as you've just described the process, it sounds like these are avenues that are available that you as an attorney take advantage of, requesting copies of the administrative record, et cetera. What might or might not a pro se litigant know about this going into it on their own with respect to what they may be able to get in advance and the role or helpfulness that may be in specifying what evidence they intend to introduce in advance?
That is a phenomenal question. Thank you so much. So your question is, what might a pro se litigant, you know how to operate the system, Cami, what might a pro se litigant not know? And I can tell you that in every case that I have had that I am considering for representation at the HSB, I have had to advise clients that they must request the administrative record, that I will need to review the administrative record before I can make a representation decision. And commonly, they have not requested that, nor have they been aware that they should be asking for those documents. And so clarifying that there should be an exchange of relevant documents or the administrative record upfront, or even requiring that the department provide that record at the initiation of a hearing with an explanation of like, these are the records we used to make the decision that we made. You know, if you think something's missing, please bring that to our attention. We don't yet know what we intend to submit as evidence at the hearing you've requested, but this is what we use to make our decision. I think could be a critical accessibility point for folks. That is assuming that someone who gets that administrative record is in a position to review it and understand what it means, which is very challenging.
And when you're saying administrative record, are you distinguishing that from a clinical record?
I am not. I don't
Okay.
think. I can't say that I have encountered anything that I would consider specifically a clinical record. In the cases that I represent in, there are such a multitude of documents that range from parent input forms to school records to physicians' documentation to specialists to psychologist records. And so I do not think that an administrative record is distinct from a medical record. I believe that the administrative record, as I use that term, is all of the documents that the department used to make its decision, plus the documents that the department describes their decision-making process through.
And so if you've agreed to take on a case, at what point do you enter the case? Because there are typically, steps prior to the Human Services Board where somebody's having the decision reviewed, I'm thinking about at the commissioner level, usually there's some sort of decision being made internally within a department. And I'm just wondering, do you provide assistance then to individuals, or are you only generally enter at the Human Service Board level?
We have a history of providing representation at Commissioner's Review. It is quite honestly, that's before my very active representation in these types of administrative decisions. My experience has been that an adverse decision goes directly to the fair hearing process. I am not confident I know how I would request a commissioner's review. And so I'll just acknowledge that. In terms of when we might come in to a case, it entirely depends on when someone has reached out to us. There are times where people have connected with someone and know we exist, and in the developmental services context are dealing with something with their developmental services provider and reach out to us for legal advice in advance of an adverse benefits decision. Or they're unhappy with their services and would reach out to us, and we can provide analysis and representation or advice in how they should pursue those circumstances. So our representation and when we come in depends a lot on when someone reaches out to us and when they're saying, hey, this is an issue and think that this is wrong and I don't know how to navigate this. In the context of Katie Beckett Medicaid, those are we get those cases after someone has received an adverse benefit. And so we are entering an appearance before the HSB, commonly after we've had an opportunity to review the administrative record and develop some evidence to really understand the case. I think I want to acknowledge to the committee that due to our very limited fiscal and staff resources, we have to prioritize cases that we analyze as being strong cases. And that is not to say that we turn away that we don't sometimes turn away meritorious cases, that we don't have the resources to accept meritorious cases. But we do have to make an analysis of whether we think that our involvement will impact an outcome. And that's a really tough decision to make. And so I think there are a lot of people who come to us seeking support who we're not in a position to offer full representation. We believe we can coach, or we'll be very candid to say we don't think you will win, but if you decide to pursue this, here's how you do it.
Well, that in and of itself, I think, is helpful to people. One, from an independent source saying, based upon what we know about the rules in this particular department or program, it is unlikely that you would prevail in your appeal. But of course, they can go ahead with it if they so desire. So I appreciate that, because you just answered the question I was going to ask, is how do you choose when you take a case or not? So since you just answered that one, do you folks have, I guess, what I would call sort of feedback sessions with various departments in the Agency of Human Services around? So if you're seeing requests, for representation around, well, you used an example around the CIS-A, so I do expect that, you'll probably, as this new case management and CIS-A and payment reform and all of that kind of stuff in the developmental service system all starts to impact individuals and their families directly, you will probably see an uptick in requests for representation. And or similarly, we're going through right now with the governor's executive order, and I know this isn't your situation, but governor's executive order around people who are homeless and who gets to stay and who doesn't get to stay. And so I would imagine that we asked this of the Human Services Board and hearing officer as well. It's like, what kind of feedback loop is, so if there's a sort of like, okay, well, we've heard, 5 cases and we found in favor of the appellant in all 5 cases. And it seems that the department's not implementing its rules. Do you have that kind of feedback loop with departments? Do you, meet with them on a regular basis and say, we're seeing a lot more requests for X, Y or Z. And, so what's happening here? And how can we be helpful to people?
Thank you, Chair Wood. I think if I may rephrase your question, you're asking about what are our systemic advocacy and direct correspondence in relationship with the department? What does that look like? If we're seeing things that seem to be similar and seeing a similar outcome at the fair hearing process, then it seems like, potentially the department should be changing something in its system to, fix the issue. Yeah, so I don't know of a specific feedback loop that we currently have established with the department. We do enjoy very strong relationships with the department's attorneys and can raise concerns and questions to them and can reach out more informally if we have a concern about how the department is making certain decisions. We engage in a significant amount of systemic advocacy through at multiple points within the department. We have been deeply involved in the payment reform we have representation on the DD Standing Committee. And so to the extent, do we have a direct feedback loop or listening session with the department? The answer is no. But in the spirit of your question, we engage in a significant amount of systemic advocacy. And quite honestly, Chairwood, some of that systemic advocacy is reflected in the cases that we take. And when we see ongoing issues, we will prioritize taking cases that reflect that issue in anticipation, quite honestly, of if we don't prevail at the HSB, appealing to the Supreme Court to get a decision on that policy issue or challenge.
As we saw this summer, we saw a decision at the Supreme Court. So, okay, other questions from other committee members? Yeah. Okay, okay, go ahead, Representative Bishop.
This one may be getting into the weeds a little bit. Back to the evidentiary question or the production of documents. I'm looking at the fair hearing rules, a copy of which we previously were provided. And I'm looking at specifically a section on fair hearings, 1000.3. And there's a section about production of documents. Production of documents talks about prior to a hearing, department or the office involved in the appeal shall make available to the appellant all documents and records relevant to the decision, which I think a plain language reading could mean that they're going to proactively provide those. But yet when I scan down further to section O on evidence, there's discussion of copies and relevance, and copies talks about upon request. So is that just if something is introduced as evidence as opposed to just information that went to the decision making? I'm just trying to get at a little bit of is this really a plain language document? And now I haven't practiced law in a while, so I'm a little rusty, but I'm finding this a little confusing myself.
Thank you, Representative Bishop. I think you certainly point out something in the rules that does make the process confusing. I think I would defer to Hearing Officer Reinhardt on the specific applicability of the rules and how he would interpret that. But suffice it to say, I think that it is common for folks to need to request to state that they would like the records. I do not know of an automatic mechanism. But again, I don't interact in every case where there's a pro se appellant. And I think I do want to be very clear. I talked some about how we engage in our decision making. I want to be very clear that we are wrong sometimes, right? Like we are sometimes wrong when we say, we think you have a really weak case and we don't currently have the resources to help you. We're often wrong. Parents specifically are just incredible advocates for their children. And sometimes a parent telling their child's story can bring that experience to life in a way that I never could as an attorney. And that quite honestly, my very legal performance can impede the strength of that story. So I just want to be very clear in acknowledging that we have to make these hard decisions about where we can apply our resources. And sometimes we're very wrong.
Thank you.
Thank you. Thank you both for being here, and it's been very helpful in understanding both the thinking about how the process could be improved and also some of the things for us to be cautious about. So appreciate that very much. And I'm very familiar with your systems advocacy and in terms of the DD Standing Committee, yes, and please give my very best to Barb Prine because I've been a fan of hers for a long time. So just say hello for me.
I will. Thank you so much, Chair Wood, and thank you very much to the committee.
Okay.
Yes, thank you very much. Have a good afternoon, everyone.
Alrighty. Thank you.
Thank you.
Thank you.
Bye-bye. Okay. So a lot for us to consider, committee. Joe, I wanted to ask you a quick question about, do you know, and it might not be a fair question without data in front of you, but about what percentage of of the folk coming to the Human Services Board are pro se, representing themselves?
So yeah, I did provide a memo with
Okay.
information. And so, and this actually, when you say pro se, I mean, some people have lay representatives. But the information in the memo is for people with attorneys and without attorneys. So for example, out of 2024 outcomes, there are 857, I'll call them substantive outcomes. They weren't dismissals, say for failure to appear. 792 of those 857 did not have, 65 had an attorney. That includes the substantiation as well. But I mean, I don't want to, not answer more than your question, but what our outcomes also show is that 90% of people who had a favorable outcome are unrepresented. So that's a pretty impressive figure. In other words, they don't have an attorney, and so 90% of them get a favorable. And so,
Yeah.
Anyway, so it's in there. It's 2024, 2023. I can run other.
Is it, did you send this in memo to us?
Yeah, it was
All right.
on March 31st.
Okay,
Yeah.
all right.
So 2020, and it's broken down between all outcomes, and then there's public benefits cases outcomes, in which the percentage, I think, is even higher without doing the math.
From you, okay, all right. Okay, thank you, Lori. I won't look for Joe, I'll look for Lori. Okay, thank you. So while that's, I think positive information, in terms of the success of the appellants, who are representing themselves, it also speaks to the fact that I think we need to make sure that what we're providing is as accessible as possible to, kind of a wide variety of individuals of all differing abilities. And I think we can improve upon that. Okay. Anybody have any off the cuff questions for Joe?
I can answer the question about records, but I mean, I don't want to overstep here.
Yeah, no, go ahead.
So records are automatically provided in every case. And so it's possible that Attorney Neller might be referring to some situations where it might take a little more time, because like in a Katie Beckman case, it could be 400 pages of records.
Yeah.
So, but it's automatic. We order the department in every case to provide the records. So there's no, again, that's our practice. Maybe the rule needs to be clearer. As far as the difference between the two rules, the difference is that the records that are provided automatically are, say, it's relevant to the decision. So what that means is that the department is taking the records that they have in their file, but it doesn't prevent the petitioner or the department from requesting other relevant records. But it starts out with the ones that are specific to their decision that they have. So sometimes, like especially in substantiation cases, the department will provide their investigative report summary, all of that information, and then the petitioner will say, "Well, I want, I want a report from another, I don't know, I can't give you another case, maybe another issue or other family services record, like case, like they have case notes that they put in that don't come in all the time automatically. So it allows some flexibility for the parties to make additional requests. So, okay.
And if it's the department sending in the record that they determined, then, they're going through, an evaluation process of whether or not, this part of the record is applicable or whether it's not. And which can sometimes leave out things that an appellant might consider relevant to their case.
Absolutely. I don't know. It's a good question because, they have their file.
Yeah.
And presumably that's gathered, organized, kept according to certain sort of guidelines.
Yeah, no, I don't think so. That'd be a nice thought, but I'm pretty sure it's not. But, and I think it's also important to understand that, at least for the majority of the cases, like in choices for care, in developmental services, in mental health, the initial decisions are being made by people who are contractors of the state and, not the state necessarily. And so, although some of that is being changed as we speak, but so important to understand that the administrative record that exists for the individual is probably more comprehensive than what the state has in their file.
That's possible.
Yeah.
Sometimes that gets teased out during the process. We don't go into a contested hearing right away. We have status conferences. We talk about what the disputed issues are. And sometimes in that process, there'll be additional documents identified.
Yeah. I mean, I think that, we've been talking about the document that you have that's available for folks. I really think at some point in time, it really would be helpful to have someone who is, I think maybe more experienced in trying to explain in plain language and also in picture format or diagram format, like, this is what happens when you file a Human Services Board appeal and, and the things like, status conferences and things like that. I mean, I think that it can be done to make it more accessible. So I'm going to give you some names of folks who might be able to help you with doing that too.
I think that's a great idea. We've discussed some other thoughts, but graphical.
Yeah, yeah.
Because that's what it sounds like. People just don't understand how to, some people might be developmentally capable.
And they're,
So I think that's a good idea.
Yeah. Well, they're very capable, but they just have different learning styles and
That's what I meant.
sometimes, yeah,
Learning styles.
yeah,
Disabilities.
yeah. Okay, thank you, Joe, and thank you for popping in and listening to testimony. We really appreciate it.
Glad I could answer it.
Of course.
It's helpful to have you in the.
Yeah, it is. Thank you. Okay, folks, that's it for today. Tomorrow, we're going to start off with our vote on 293, and then we're going to move to 92, and then we're going to be talking about play therapy, and then back to S36. So we have 4 different topics tomorrow. Lori hates it when I do that.
It's all good.
So apologies. And the other thing to know is that we are trying to get a couple of updates on 2 things from DCF. One is on the Reach Ahead pilot that was in the budget from, I think that we passed in 23, so I think it was for the 24 budget. So we are trying to get information about that. We are also trying to get testimony from the department about a status update on implementation of the governor's order with regard to the general assistance emergency housing quote unquote program. So we're trying to get both of those things sometime in the next, I want the GA update sooner rather than later. And then we're trying to get information about the Reach Ahead and what's happening with that. But there is some staff issues with that, people being out and the like. So anyways, just to give you a heads up on a couple of the things that we're doing that aren't currently on the agenda.